Hello, everyone. Good afternoon. My name is Ayla Alves. As Luis already presented, I'm a PhD candidate at UNSW Law and Justice. And also a member of the Australian Human Rights Institute. The title of my presentation is Beyond the Anglosphere in the International Protection of Indigenous Cultural Heritage. Oh, that one.
There we go.
Okay, so a brief introduction on my presentation. It's part of my PhD thesis, so it's one of the chapters, very much work in progress. I'm looking forward to hearing your comments and suggestions. But the broader aspect of my research is, as Luis already said, the regulation of cultural appropriation of Indigenous heritage in international law. I've also identified some impasses in the current regimes that somewhat cover Indigenous heritage protection. Those will be international cultural heritage law, international intellectual property law, and international human rights law. Here I'm focusing on Indigenous traditional knowledge and traditional cultural expressions. I'm not looking at genetic resources and associated traditional knowledge. So some other regimes that could be applied, I'm not considering them. And analyzing those regimes and identifying some impasses that and some shortcomings, I also looked at current efforts in international law that are trying to provide a better protection for Indigenous heritage internationally. And that the main forum doing that kind of work now is the World Intellectual Property Organization Committee on Intergovernmental Committee on Intellectual Property, Genetic Resources, Traditional Knowledge and Folklore. And I'm focusing again on traditional knowledge and traditional expressions only. And given those impasses, and given that the work at the IGC has been lingering, not extremely productive, what I propose in this chapter in my thesis is to look, to try to identify new approaches to address the issue of Indigenous heritage protection. And what I propose is that international law looks at Latin America for some solutions to the impasses. So the question that I try to address in this chapter and in the presentation is, what can international law learn from Latin American experiences? And then I focus on some legal developments in Latin American countries, specifically Venezuela, Panama, and Mexico. And I have a reason to choose these countries, but I'm not going to go through them now. Especially because these countries, they have specific legislation dealing with Indigenous TK and TCEs and addressing cultural appropriation. So basically, I think it's important to shift the approaches in international law and look at Latin America, because these countries have already done what international law has been trying to do. Of course, it's problematic to take from the domestic to the international, but I think it's possible. And I think international law can learn some lessons from these domestic experiences and use them to solve or address some of the international impasses. So more broadly, why Latin America, not African countries that already have that kind of legislation? Firstly, I propose a move from the center to the periphery of international law, so focusing not on Western developed countries' approaches, but more the periphery, because the center has not been incredibly helpful when it comes to Indigenous rights internationally. And I also propose a move beyond the Anglosphere, or I could more specifically say the Kansas states, Canada, US, New Zealand, and Australia, because especially in the scholarship, it feels like a lot of focus is placed on those states, but those states do not have the kind of legislation specifically dealing with Indigenous TK and TCEs as Latin American countries have. So why are we not taking a better look at Latin America? And finally, because Latin America has demonstrated a stronger commitment internationally to the protection of Indigenous rights. Out of, I think, 24 ratifications of the ILO 169 Convention, 14 are from Latin American countries, so more the majority. Also, the Latin American countries adopt the UNDRIP from the beginning, whereas the Kansas states didn't, only afterwards. Latin America also has the ADRIP, the American Declaration on the Rights of Indigenous Peoples, and also benefits from the inter-American system of human rights. So I think there's a lot going on in terms of advancing Indigenous rights internationally and regionally that justify this shift, looking at Latin America for solutions. So a brief structure of my presentation, I'll restate the impasses. So the shortcomings and difficulties in considering international regime against cultural appropriation. And in my chapter, I went through the whole analysis of the domestic regimes and against the same themes that I analyzed the international regimes against in the previous chapter. I'm not going to go through all of that analysis now, but I'm going to focus on the lessons that I think international law could learn from the overlaps between the domestic and international experiences, but also from the divergent paths that I could identify between both. And then I'm just going to conclude briefly as well. So first, the themes that from which I identified some impasses are the uses of heritage and scope of protection in each regime. So what each regime understands as protectable heritage, whether they recognize indigenous peoples as stakeholders and rights holders, whether they make an effort to accommodate indigenous worldviews, whether indigenous peoples participate in the drafting and in the implementation of those regimes, then the actual implementation tools and available remedies that each regime offers, and finally, whether the regimes provide an indigenous right of control over the heritage. So these impasses these themes lead to impasses after the analysis of each of the regime. So I'm going to try to assess whether the domestic regimes provide solutions to those impasses. And the lessons that I learned from that analysis, first, in terms of the uses of heritage and scope of protection, domestically, there's a broader protection. So, for example, the Mexican Act, it expressly acknowledges a right for indigenous peoples to engage with the heritage actively and creatively, which is quite different from what international cultural heritage law does, for example, which is a very conservationist and object-centric kind of protection. So it's very, let's try to protect heritage as it was in the past for the benefit of generations in the future, whereas the current, the present and more political uses of heritage are ignored. So I think the domestic jurisdictions provide a broader protection, acknowledging both the intrinsic and extrinsic uses of heritage. So lessons to be learned from international law, from those domestic experiences. A regime in international law dealing with appropriation has to enable and protect all uses and values of heritage, intrinsic and extrinsic, and also the acknowledgement that heritage is alive and dynamic. We cannot apply a fully conservationist, object-centric approach. Moving forward, concerning indigenous peoples as stakeholders and rights holders, the domestic legislations, they are indigenous specifics. They target indigenous heritage directly. So indigenous peoples are directly acknowledged as rights holders, but they also provide a collective right dimension as well, which is something that is very much missing in international law. Lessons to be learned. This recognition of indigenous peoples as rights holders is fundamental when dealing with matters affecting indigenous peoples, which is obvious, but still not quite incorporated in international law, apart from the declarations. Beyond recognition, it has to be the recognition of collective legal subjectivity as well. And it's not just recognition, it's also providing the means and the mechanisms for indigenous peoples to exercise their rights and claim their remedies. It's not just about saying indigenous peoples have these rights, but also providing the means for them to achieve them. About accommodation of indigenous worldviews and context. Domestically, again, there's a much stronger effort towards accommodation. However, I noticed that especially the Mexican Act, it really privileges the collective rights or collective heritage over individual, which is something that might not fully address some of the needs indigenous communities might have, but I think it's important to have that collective primacy and also expressly acknowledge indigenous worldviews, beliefs, the intergenerational nature of their culture. The Panamanian regime also provides that the protection offered has no term of duration, so it can be perpetual protection, and requires no fees for the registration process, which I also find would be it was quite unique and accommodating. So lessons to be learned in international law from those domestic experiences. I've been talking about indigenous views and context, and it sounds very generalizing, but of course, the experiences are much, much more diverse than I'm suggesting. So the international regime has to accommodate indigenous heterogeneity. So it has to be somewhat flexible to enable the diversity of indigenous views to be acknowledged in the regime. Despite heterogeneity, I think there are some commonly shared features that an international regime has to accommodate anyway. One of them is the orality of indigenous heritage, collective heritage, sometimes the need for perpetual protection, in the general features of indigenous heritage, which are oral, transgenerational, can be spiritual, and they may also have secret and sacred heritage that requires special protection. And there's also a need to accommodate indigenous customary laws and normative systems. I think it's important to at least find a way to coordinate the mainstream Western regimes with indigenous laws. And naturally, this effort of accommodation will entail some departure from Western concepts and notions. And I think that there shouldn't be a problem with that. The domestic regimes have done it. I don't know why international law couldn't do it. It's a bit different, but I still think it's a lesson that international law should learn from the domestic experiences in Latin America. Then about indigenous participation, the domestic regimes. So the Venezuelan Act had 3 indigenous parliament members in the drafting commission, the commission that drafted the bill. And Panama is quite an interesting example because the Panamanian Act was a direct response to indigenous people's claims in Panama against appropriation of a very important traditional type of clothing for the Kuna community. So the regime originated as a response to indigenous claims. It was indigenous lawyers that drafted the bill, and indigenous representatives participated throughout the legislative process. So there was a very, very strong participation of indigenous peoples in the Panamanian process. And back to Venezuela, the text of the document adopts a principle of active and protagonist participation of indigenous peoples. So I think these are important lessons that international law could also learn. Firstly, that indigenous participation is a precondition to legitimacy. And then the Mexican Act is very interesting in that aspect because it's an act from 2022. So just a few months ago, it was published. And there has been critiques to this act because there's no indication of consultation, prior consultation at all. And that lack of prior consultation has become a legal ground for an action of unconstitutionality concerning the act. So there's an action pending before the Mexican Supreme Court claiming that the act is unconstitutional because there has been no prior consultation. So in that sense, consultation, which could be an element of participation, is a precondition to legitimacy. Also, participation has to be active, pervasive, decisive, and protagonist. It's not just box ticking. It is also necessary throughout the decision-making process, considering a new regime in international law, but also negotiating, drafting, implementing, and eventually revising the regime according to changing needs. And as before, it's not just about providing for a right to participation, but also the mechanisms to operationalize that kind of right, such as consultation, processes to obtain prior informed consent, culturally adequate access to discussions, which may include translation in languages that indigenous peoples can understand, and so on. About implementation and redress domestically, that speaks to the nature of domestic systems and international systems, of course, going to be different, but domestically, the acts provide very advanced structured systems for implementation with specific targeted organs, with specific functions in the implementation regime. Some of the acts, so in different levels, the 3 countries, they provide a need for consultation and consent of indigenous peoples in the implementation of the act. And also very interestingly, Panama and Mexico provide for criminal sanctions concerning appropriation. Even though there has been indigenous feedback about these acts saying that they're very, very positive developments, there has also been claims that the implementation systems are complex, extremely bureaucratic, and confusing. So that is still a lesson for international law to learn. So among the lessons is that the implementation and redress system for an international regime has to be culturally adequate, has to provide accessible tools. So being easily accessible, affordable, fair, expeditious, providing the adequate mechanisms, accommodating collective claims, relating to Indigenous participation has to be guided by Indigenous people's autonomy and control in deciding the implementation mechanisms. Also providing some coordination with Indigenous law and normative systems, and also considering a variety of possible remedies, given the variety of possible damages that appropriation might cause. And these are some of the elements that are found in the domestic regimes and not in the current international protection. Finally, concerning Indigenous control domestically, the Venezuelan and the Mexican acts mention control specifically. In the Mexican act, the provision that mentions control resembles Article 31 of the UNDRIP very, very much. So I found it interesting that the Mexican act, which is the most recent one, has benefited from international discussions on this topic a lot. So domestically, there are these two acts that provide for control expressly, but also they foster consultation, consent, also the right to revoke consent, the right for Indigenous peoples to decide according to their own rules what are the elements of their heritage that are accessible to outsiders, which aren't, and so on. I think those are mechanisms to operationalize control. And the lessons to be learned is that control is a tool for self-determination. It's hard for Indigenous peoples to freely pursue their cultural development without control. And this control has to be according to Indigenous law, needs, and interests. So it cannot be according to whatever Western idea of control there might be. Also, there has been growing openness concerning this recognition of Indigenous control, which should be a hint to international law to say this is fine. We can perhaps compromise a bit of state control in favor of that recognition. And again, it requires the means and the context to materialize a right to control. And providing Indigenous control over the heritage will probably entail some compromise of state control, of course, that is necessary, but it's also fair and it's very long overdue because Indigenous control can work as a response to historically marginalizing and disempowering approaches from states and from international law to Indigenous culture and Indigenous control over their cultures. These are some of the findings or the lessons. This is very superficial, but I'm happy to perhaps go a bit deeper into my research in the questions. But just recapping and concluding the presentation, there is a gap in the international protection of Indigenous heritage against appropriation. The current efforts trying to fill that gap are lingering or not very productive, especially at the IGC. So there's a need for different approaches to overcome those obstacles. The one I propose, the new approach I propose, is a move from the center to the periphery of international law, which would also entail looking beyond the Anglosphere, beyond the Kansas states, into Latin American countries, but also some African countries that can be helpful as well. And one of the reasons for that move, that shift, is because Latin American domestic laws have achieved what international law has been trying to achieve. So we should try to take some lessons from their experiences. And lessons can be learned both from the overlaps between the domestic and international regimes and the divergent paths. And I believe that if international efforts, including the IGC, considered those lessons, it would be possible to solve the impasses and shift the focus of how to solve the impasses as well. I hope that wasn't too confusing. Thank you very much. And I look forward to your comments and questions.